But when an Italian tells you you're a part of a family, that is something completely else. You are the most polite actress I have ever met in my life. Also, I want to tell you that I've learned so much from you on set, and because you made me grow up so much, and I love you like crazy. Crazy.
So
I swear to God.
I'll give you the money for that later.
Yeah,
that was
thank
good. Good work. Good work.
It was 1,000.
Hi, besties. Okay, if you've been waiting for Wayfarer, along with Baldoni and all of these parties to finally clap back at Blake Lively and these constant attacks through the court records and the requests for sanctions and the name calling and all of the behavior that has left people feeling so frustrated, like, Wayfarer, where's your spine? Well, they responded to the motion for sanctions, and I think they might have found their spine. The problem here is I'm not sure how the judge is going to react, because it kind of feels like every single time they clap back, the judge is all, I don't know, I believe Blake Lively. But I want to note something. So many of you in my comments have been like, why is it that Blake Lively and all of them, Ryan, and we know that Ryan's behind it, can file whatever they want? They can say all these nasty things in the court filings. They can lie, misrepresent. And yet when Wayfarer does it, they get in trouble. Or why doesn't Blake's team ever get in trouble for all of their accusations and despicable behavior towards Brian Friedman? Because this is a court, you guys. You are literally supposed to respect your opposing counsel because they're an officer of the court. Well, they have clapped back and quite hard in their objection and opposition to sanctions. And what they had to say is wild. Miss Lively nevertheless insists that Mr. Friedman is the architect of a far-reaching scheme to smear Miss Lively. She points to 10 statements in which Mr. Friedman questioned the validity of her claims, addressed the possibility that Miss Lively would continue her deposition, which she did, and referred to Miss Lively as a Hollywood elite, which of course she is, having worked her whole career to become. Burn. Lively contends that Rule 3.6 applies because Friedman's statements challenge her character, credibility, or reputation. She misconstrues 3.6, which does not bar public statements by counsel, even statements critical of an opposing party. The only kinds of statements that are barred are those that could prejudice the matter, okay? The chief failing in Miss Lively's motion is the underlying assumption that any statement that touches on a party's character, credibility, or reputation automatically triggers a substantial likelihood of prejudicing the procedures. This is not the case. They spend quite a bit of time in this filing sort of talking about how she provides no evidence about how they tainted the jury pool and how anything that they've said would risk the actual trial that's not even slated to go to trial until March of next year, or that she's a failure to demonstrate a substantial risk of material prejudice alone dooms her request. And they went right for the jugular on page 5, and it says, Miss Lively conveniently ignores her own counsel's very public campaign to savage defendants and their counsel in the public eye. Miss Lively similarly ignores that she was a highly divisive figure long before Mr. Friedman came on the scene. Discord on the Ends With Us set attracted media attention while the film was still in production. Public and media interest spiked when Miss Lively encouraged cast and crew members to defriend and unfollow Mr. Baldoni on social media, froze Mr. Baldoni out of the marketing campaign for the film he produced, directed, and starred in, and banished him and his family to the basement of the film's premiere in August 24, long before Mr. Friedman engaged in late December of 24. Then Miss Lively poured fuel on the fire when she and her counsel provided a draft of her CRD complaint to the New York Times before it was filed. That sounds like it's going to be appealed. Miss Lively's post-litigation conduct has done nothing to endear her to the public, the press, or content creators. A recent barrage of subpoenas has angered and alienated those already critical of Miss Lively, forcing a number of them to seek this court's intervention. A footnote there says, to the best of the Wayfarer party's knowledge, the subpoenas have failed to yield any evidence or interference by Mr. Friedman. So they've gotten no evidence of manipulation or interference by Friedman, despite subpoenaing 107 creators. Blissfully tone deaf to her own conduct, Miss Lively has not only unwilling to accept that her own celebrity and actions have generated the media frenzy she now complains of and the weight of negative publicity against her, she conveniently ignores that she and her counsel have been less than shy about publicly bashing Mr. Friedman and the Wayfarer defendants in the press. Nevertheless, Ms. Lively seeks monetary sanctions, attorney's fees, a reprimand, and revocation of Mr. Friedman's pro hac vice admission for statements primarily relating to whether Ms. Lively would appear at a deposition and the falsity of her claims. I just want to say something. Ellen Garofalo is amazing. She's a wordsmith. She's a great technical writer, but this is an amazing piece that she put together. Kevin Fritz is signed to the document, but Ellen's name is also signed. So this appears to have been drafted by Ellen, who is a partner to Mr. Friedman and his law firm, the trial attorneys, the lead attorneys, and then Kevin Fritz and Mitchell Schuster are the local attorneys that submit everything for them. So this appears to have been drafted by Ellen, who does an amazing job here. They reframe the campaign that she's claiming that they've done to her, and they reframe it as her relentless campaign against Friedman. After the film's release, this motion is the latest salvo in Miss Lively's relentless war against Mr. Friedman. It comes on the heels of a string of motions calculated to intimidate counsel and curb Mr. Friedman's statements in defense of his clients, including a Rule 11 sanctions motion against the parties and their counsel and a subpoena directed at Mr. Friedman's law firm, seeking, among other things, all communications and agreements with content providers. But that is not all. She sought to bar him from taking Miss Lively's deposition and has repeatedly added gratuitous swipes at Mr. Friedman in a string of motions unrelated to the negative publicity which she alleges smeared her. He also notes that on August 8th, the court wisely issued a long overdue order advising all individuals filing documents in this case not to make submissions using language that is disrespectful to the parties, their counsel, or the court. The Wayfarer parties are hopeful that all parties will comply with this order and cease from the incessant personal attacks on counsel. That's putting them on notice, because that order by the judge stated that anyone that violates this order could be placed in contempt of court. And if something is filed by her in the future that is defamatory, or it's gratuitous, or it's rude, or it's a verbal attack, or it's just disrespectful, they can file a motion to the court and seek sanctions for the violation of the court order. So it's just a very subtle way of telling Lively that if they continue to go down this path, we will have no problem seeking sanctions against you if you keep going this way. It would appear that this final motion for sanctions was where Wayfarer and Friedman have hit their limit. They are done playing this game, and more often than not, they have refrained from being snarky, from being disingenuous, for being disrespectful. They have not resorted to calling names of any of her lawyers, even though the lawyers, in my opinion, deserved no respect because they've had no respect for anyone else in this case. But Wayfarer's attorneys have not. They have made comments that have been flippant and at times reactionary. But here they're saying, if you continue this, it's going to happen to you. And we hope that now that there's an order, you are on notice for your bad behavior. And then my favorite part of this filing is that he writes, in the latest assault, that's violent language, she cites 10 statements by Mr. Friedman issued between February 5th and June 11th as violative of Rule 3.6. And then they list out the 10 statements that were made. And they have a footnote because one of them is a statement that Megyn Kelly made, which is not Ryan Friedman. And another one is about Ryan Reynolds, who's not a party to the proceedings. So it's irrelevant. They use arguments about previous rulings that have been found in courts that have ruled that it's nonsensical that statements made to reporters before a trial, years before it goes to trial, could influence a jury pool. They name numerous cases that have been across the country that have found that most attorneys that are speaking to the press that the trial date was too far in advance for them to be prejudicial. And most importantly, they say that his statements fall within the express exceptions of this rule. And that's assuming the court finds that any of the enumerated statements pose a substantial risk of materially tainting the jury. His statements are not prohibited, but are subject to its exceptions. It does not apply to statements asserted without elaboration concerning the claim, offense, or defense, information contained in public record, or the scheduling or result of any step in litigation, or to a statement that a reasonable lawyer would believe is required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client to mitigate recent adverse publicity. And he says that his statements are reasonably required to protect the parties by countering the substantial prejudicial effect of publicity initiated by Lively and her counsel. They say Mr. Friedman's statements were not made in a vacuum. As recognized by the expressed exception to Rule 3.6, lawyers have a right, indeed a duty, to publicly defend their clients. Put another way, nothing in 3.6 divests a lawyer of his or her right to defend against adverse publicity promulgated by an opposing party or his or her counsel. In fact, this court has recognized a lawyer's right to speak out. She cites a literal quote from this court from a hearing from July 25th. And Judge Lyman said this. So if Miss Garofalo leaves this courtroom and gives her spin on what I've said or what you've said or what she said, that would be picked up. If it was Mr. Friedman who was here and he gave his spin, that would be picked up. Clients do have a right to have their attorneys speak to members of the press, particularly in high-profile cases, and give their interpretation. The public has an interest in that also. I wouldn't begrudge you speaking to members of the press, and I'm not going to begrudge Ms. Garofalo doing that. Making clear that in his court, given the amount of public interest, they have a right to share their interpretation with the press. And he's not going to stop them from doing that. There is no serious dispute that her lawyers, sometimes called spokespersons, have disseminated a barrage of negative statements impugning Mr. Baldoni and the defendant's credibility, character, and reputation by alleging, among other things, that Justin Baldoni lied about his longstanding commitment to women's rights and betrayed victims of sexual abuse. For instance, and they have a lot of these statements, on January 7th, her legal team released a statement to E! News that this is not a feud arising from creative differences or a he said, she said situation. Sexual harassment and retaliation are illegal in every workplace and in every industry. A classic tactic to distract from allegations of this type of misconduct is to blame the victim by suggesting that they invited the conduct, brought it on themselves, misunderstood the intentions, or even lied. Another classic tactic is to reverse the victim and offender and suggest that the offender is actually the victim. These concepts normalize and trivialize allegations of serious misconduct. Media statements are not a defense to Ms. Lively's claims. We will continue to prosecute her claims in federal court where the rule of law determines who prevails, not hyperbole or threats. And that says, lawyers slam more attacks from Justin Baldoni's legal team. And January 16th, Deadline quoted Lively's counsel as saying, this latest lawsuit from Justin Baldoni, Wayfarer Studios, and its associates is another chapter in the abuser playbook. This is an age-old story. A woman speaks up with concrete evidence of sexual harassment and retaliation, and the abuser attempts to turn the tables on the victim. This is what experts call DARVO, deny, attack, reverse, and victim offender. Further, Wayfarer has opted to use resources of its billionaire co-founder Steve Sarowitz to issue media statements, launch meritless lawsuits, and threaten litigation to overwhelm the public's ability to understand that what they're doing is retaliation against sexual harassment allegations. They are trying to shift the narrative to Miss Lively by falsely claiming that she seized control and alienated cast from Mr. Baldoni. The evidence will show that the cast and others had their own negative experiences with Mr. Baldoni and Wayfarer. The evidence will also show that Sony asked Miss Lively to oversee Sony's cut of the film, which they then selected for distribution and was a resounding success. Their response to sexual harassment allegations, she wanted it, it's her fault. Their justification for why this happened to her, look at what she was wearing. In short, while the victim focuses on the abuse, the abuser focuses on the victim, and the strategy of attacking the woman is desperate. It does not refute the evidence in her complaint, and it will fail. In January, another statement to Deadline. They stated any woman who has been inappropriately touched in the workplace will recognize her discomfort. They will recognize her attempts at levity to try to deflect the unwanted touching. No woman should have to take defensive measures to avoid being touched by her employer without their consent. While they are focused on media narratives, we are focused on the legal process, and we are continuing our efforts to require Mr. Baldoni and his associates to answer in court under oath rather than through manufactured media stunts. On February 5th, in a press release, another day, another state, another 9-figure lawsuit seeking to sue Miss Lively into oblivion for speaking out against sexual harassment and retaliation. This is not just a publicity stunt, it is a transparent retaliation in response to allegations contained within a sexual harassment and retaliation complaint. Do you see how they framed it as employment retaliation to file a lawsuit? That was filed by Jed Wallace, who was never her employer. On February 18th, the statement to Deadline, over the next several weeks, we will move to dismiss the utterly meritless lawsuits brought against Miss Lively and Mr. Reynolds, and we will move full speed ahead with discovery that we expect will reveal shocking details about the depths to which the defendants have sunk in with their unending efforts to bury, ruin, and destroy Miss Lively and her family. Another one, February 28th, Lively's spokesperson. What is Brian Friedman hiding? After promising to release all the receipts, he ran into court to keep secret the phone records of who Baldoni, Heath, Sarowitz, Nathan, Wallace, and Abel were calling during their retaliatory campaign. By the way, that motion for that sanction to quash was granted, and the judge found that her subpoena of the phone records was an invasion of privacy. Another one on February 28th, a spokesperson stated, in the motion to dismiss, the New York Times correctly calls out Justin Baldoni's lawsuit for what it is, a shameless PR document that has no business in a court of law. For years, Baldoni urged men to listen and believe women, but when a woman spoke out about his behavior, he and his billionaire backer, Steve Sarowitz, used a social media combat plan to scorch earth and try to bury and destroy her, along with the media who reports on it. These bullying tactics will not survive in court, and everyone should see their meritless claims for what they are. Today, the court rejected Wayfarer parties' objections and entered the protections needed to ensure free flow of discovery material without any risk of witness intimidation or harm to any individual's security. This was to Deadline. With this order in place, Ms. Lively will move forward in the discovery process to obtain even more evidence that will prove her claims in court. March 20th to Deadline. This meritless and retaliatory lawsuit runs headfirst into 3 legal obstacles, including the litigation, fair point, and sexual harassment privileges, the latter of which contains a mandatory fee-shifting provision that will require the likes of billionaire Steve Sarowitz and Wayfarer Studios and others that brought frivolous defamation claims against Miss Lively to pay damages. In other words, in an epic self-own, the Wayfarer party's attempt to sue Miss Lively into oblivion has only created more liability for them, and deservedly so, given what they have done. May 9th, in a statement to Deadline, Mr. Baldoni, Mr. Sarowitz, and the team continue to turn a case of sexual harassment and retaliation into entertainment for the tabloids, going as far as suggesting that they sell tickets to a concert venue, Madison Square Garden, to witness Miss Lively's deposition, to subpoenaing Taylor Swift, a woman who has given a voice to millions the world over. This is a very serious legal matter, not Barnum and Bailey's circus. The defendants continue to publicly intimidate, bully, shame, and attack women's rights and reputations, including in the past month, seeking to strike down for all a powerful California victims' rights law, calling it unconstitutional. The disturbing actions by a billionaire men who made their careers as female allies and their team continue to show their true colors. May 15th. Another day, another bogus filing designed for clickbait. We reiterate our unequivocal denial, which Mr. Friedman has now admitted rely completely upon a source, no matter who it is, that doesn't even claim to have witnessed the conversations that Friedman describes, making this triple hearsay statement as unreliable as information reported from children in a game of telephone. These claims remain completely untethered from reality. To be clear, the conversations as described did not happen, and we will hold him accountable. On May 19th, Deadline reported a statement from Lively's representative. Does anyone believe that Wayfarer is genuinely investigating a film set workplace that no longer exists? On June 9th, Gottlieb to CNN says, these lawsuits that are designed to punish people that speak up won't work. This is a message for others who may want to do the same. Also on June 9th, Gottlieb to TMZ. Baldoni's meritless sham claims designed to distract from Lively's claims, designed to distract from retaliation claims that they launched. They haven't just attacked Blake Lively and Ryan Reynolds, they have attacked the laws that are designed to protect victims of sexual assault and sexual abuse. Victims of sexual abuse, they have attacked the laws that are designed to protect sexual abuse victims. It ends in trial, in open court, on the record, under oath, and we are confident we will prevail. That is, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14 statements, and then they have more. They say that she has made efforts to widely disseminate media to alienate and sway potential jurors who might be among Taylor Swift's millions of fans against Mr. Baldoni and Wayfarer parties. We are pleased that Justin Baldoni and the Wayfarer parties have withdrawn their harassing subpoenas to Taylor Swift and her law firm. We supported the efforts of Taylor's team to quash these inappropriate subpoenas directed to her counsel, and we will continue to stand up for any third party who is unjustly harassed or threatened in the process. The Baldoni and Wayfarer team have tried to put Taylor Swift, a woman who has been an inspiration for tens of millions across the globe, at the center of this case since day one. Deadline reported that Lively's spokesperson said of their client's close pal, who was popped up in more than one filing or two since this all started, with another Simple Favor actress's CRD complaint in late 24, exploiting Taylor Swift's celebrity was the original plan in Miss Nathan's scenario planning, and it continues to this day. The statement adds, with a swipe at Baldoni's crisis management PR chief, faced with having to justify themselves in federal court, they folded. At some point, they will run out of distractions from the actual claims of sexual harassment and retaliation that they are facing. Another statement on June 13th to Deadline. Justin Baldoni and the Wayfarer parties are still demanding access to Taylor Swift's private communication despite having already subpoenaed and withdrawn the subpoena after they got all they needed. As reflected in today's filing, their intent to drag Swift into this was evident as far back as August 24, when PR crisis firm led by Melissa Nathan included her in their scenario planning document. And then Wayfarer's argument is 3.6 does not require Friedman to stand idly by while Ms. Lively and her counsel conduct a transparent campaign to savage Mr. Baldoni and the Wayfarer defendants and their counsel. To the contrary, the express language makes it inapplicable to statements that a reasonable lawyer would believe is required to protect a client from the substantial prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Ms. Lively conveniently fails to explain how these public statements differ from Mr. Friedman's. In fact, they are not. Like the statements Lively complains of, they challenge defendants' truthfulness, attack Mr. Baldoni's character by repeatedly stating that his work to protect women was a fraud, and in fact, he's a typical serial sex abuser and defendants are bullies. Unlike Mr. Friedman's statements, those from Miss Lively's counsel barely conceal their intent to taint the jury pool, particularly to millions of fans who follow and support Taylor Swift. Succinctly put, if Mr. Friedman's statements are sanctionable, so are those of Lively's counsel. The primary argument here is that Mr. Friedman was making statements that were made to counter what was the deluge of publicity that Lively and her counsel put out into the media, which is permitted by Rule 3.6. And it doesn't rise to bad faith that's required for sanctions. And they'd like them to deny the sanctions. I hadn't heard all of those statements by Lively's counsel. And even reading them, I'll say one thing that is very obvious to me. They are being very deliberate in how they frame this as a case of sexual harassment, and that they are framing it so the average person will look at him as an abuser. He's never been charged with a crime ever. He's never been charged with sexual assault or sexual abuse of any kind. No one has ever filed criminal charges against this man. But the strategic messaging here is that if you don't believe her, you're just being like everyone else who is always blaming the victim. It feels very post Me Too in that believe all victims without evidence. And it brings up key points of survivor language that makes it almost uncomfortable for the most reputable person and morally, ethically equipped person to doubt her. They are trying to make it so that you all don't think critically, don't ask questions, and just believe. They are weaponizing survivor language that women have worked so hard to achieve to be believed, and they're using it against us. That's what I got. Because if you hear those statements over and over and over again, and it's just drilled into you, you're going to think that Justin is a bad guy that sexually assaults women and then goes on a litany of retaliation against his victim. I can't say for sure what happened on the set, but according to the leaked text messages that were now unsealed, the only claim that Lively made to anyone at Sony had to do a comment about calling the character's outfit sexy. That was the only complaint that she and Jenny Slate filed. There was never a complaint to HR about lingering kisses or being fat shamed or being weight shamed or having their lip discreetly bitten. There was no claims to HR that there was unwanted kissing. Nothing. There was no complaint to HR about porn addictions or describing genitals. The only complaint she gave to anyone was that he called the character's outfit sexy. That's in the records that she unsealed. Two people, the same incident, that's the only complaint. The other complaint has to do with an apartment that Jenny Slate was having issues with, and Mr. Heath offering to pay for a new apartment for her to stay so she would and her child would be safe. Jenny Slate's 2 complaints, Blake Lively's 1 complaint. No other complaints. None of that involves sexual assault. I do hope they deny the sanctions because while Lively has a right to defend herself or to defend her lawsuit, I think in a case like this where the sexual harassment isn't obvious, isn't even visible to most humans with a brain. I mean, I don't know in what world looking at someone in the eyes is sexual harassment, but that's Blake Lively. So we'll have to see how it's responded by the judge. But in terms of the court and in terms of what they're telling Lively is that if you continue to go down this path, we will seek to have you violated for not standing by this court order that you not disparage and attack us and malign us and be inappropriate and disrespectful and use appropriate, respectful language in all of your filings. And if you don't, we will have you and file a motion to have you violating a court order and have you held in contempt. And if our conduct is sanctionable, so is yours. This is such a messy case. It is such a painful one to cover because it goes to the heart of victims of sexual assault, and it's made a mockery out of a book and a film that could have done so much to help victims. And it's hurting those of us who have been victimized by sexual assault or harassment because it's making all of us look like liars. Thank you, Blake Lively. What are your thoughts? Do you think the judge will step up? Are you happy to see Wayfarer finally grow a spine? Tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.